Hello everyone. Today I'm going to discuss with you the evolution of international criminal law. So we will be seeing the various instances like how the international criminal law has evolved. It has not evolved to the fullest form till now. It is still in the period of evolution. It is evolving like the international migration law itself. The international criminal law is also evolving with time. So there are various intense instances how the international criminal law has been evolving. So in many ways, this international criminal justice for the atrocities like crimes of genocide, crime against humanity, and war crimes, it is said that this truly began with the post World War II trials. Okay, soon after the Second World War, like that is from 1939 to 1945. After that, it has mostly began. Most notably, you can say the International Military Tribunal at Nuremberg Tribunal. That Nuremberg Tribunal, that is related to the German, that is related to the German period, like when there was a like the Hitler's rule, and the that trial took place because of the Holocaust and the war crimes. You can say that these were a series of military tribunals which were held after the World War II by the Allied forces under international law and the laws of war. And these trials, they were mostly most notable for the prosecution of the prominent members of the political, military, judicial, and economic leadership of the Nazi Germany who planned, carried out, or otherwise participated in the Holocaust and other war crimes. And the trials were held at Nuremberg, Germany, and their decisions it marked a turning point between the classical and contemporary international law. You see that. So these were considered to be the like how that the first instance how the international criminal law were evolving from that time. So you see that as momentous and influential as the Nuremberg Tribunal were and continue to be on the field, international criminal justice is also the product of numerous other important events. It's not that like it has started from this like only from the Nuremberg Tribunal itself, but it started, even like prior to that, there were certain events even prior to that, pre-Nuremberg events. So there are many as various instances like that. So in the year 1870s, like in that particular year, like Gustav Meunier, one of the founders of the International Committee of the Red Cross, he proposed a permanent international code in response to the devastation of the Franco-Prussian War. So as a result of this, we see, as a result of certain situation or circumstances, if it emerged like that, then only it if there is a problem to solve that problem, certain like solutions come up. So to deal with the Franco-Prussian War, this Gustav Meunier, who was one of the founder of the International Committee of the Red Cross, he proposed that there should be a permanent international like code. So that was also like you see these were the pre-Nuremberg trials before the Second World War, and so this is also can we say it to be like the how the international criminal law has initiated, and this Franco-Prussian War or the Franco-German War, it is often referred to in France as the War of 1870, and it was a conflict between the Second French Empire and the German states of the North German Confederation, led by the Kingdom of Prussia. So this was the war taking place between the two. So as a result of this, to solve these issues, this founder of the International Committee of the Red Cross, he proposed that there should be a permanent international court to remedy this situation. The next is like your 1919. In the year 1919, 1919 can be soon related to the end of World War One, and after the World War One also related to a lot of massacre in the society. There were a lot of crimes you can relate it to it. There were like, bloodsheds all over. So following this World War One, the negotiators of the Treaty of Versailles, it proposed for establishing an international court to try the Kaiser and German war criminals. And this Treaty of Versailles, this was the most important of the peace treaties that brought World War One to an end. The treaty ended the state of war between the Germany and the Allied powers, and it was signed on 28th of June 1919 in Versailles, exactly 5 years after the assassination of Franz Ferdinand, which had directly led to the war. Okay, so this was one of the most important treaties which led to the end of the war. And the negotiators of the Treaty of Versailles, it proposed to establish an international court to try the Kaiser and German war criminals. And though the Kaiser was not never very tried, but the proposal remained in Article 227 of the Treaty of Versailles. So it remained in that very, that article 227. So it is very important in this regard how after the World War One also the negotiators had proposed that there should be an establishment of an international code. And this article 227 it called for a five-judge tribunal to put the abdicated Kaiser Wilhelm II on trial or a supreme offense against international morality and the sanction of treaties. Okay, so this is how you can say that even before the pre-Nuremberg trials, there were a lot of instances how this international criminal law was evolving. Then in the year 1940s, there are various instances how the international criminal law criminal justice system was evolving. In the year 1943 to 45, the United States and its allies signed the Moscow Declaration of 1943 and the Potsdam Declaration of 1945, which discussed the need to punish the war crimes committed by German and Japanese governments respectively. So you can see that even in during this period, the Moscow Declaration and Potsdam Declaration, they also, discussed in this. There were the discussion how to punish the war crimes which were committed by the German and the Japanese government respectively. Next came in the year 1945 to 1946. That is after the Second World War. Like the Allies set up the Nuremberg and Tokyo tribunals to try the German and the Japanese war leaders respectively. As I have already told you regarding the Nuremberg tribunal, why it was held because after the World War II, saw there was a lot of Holocaust and war crimes which led to the trial of the Nuremberg in Germany, and that was the Allies also set up the Tokyo tribunals to deal with the Japanese Japanese war leaders. So you see how this during that time also the international criminal law was evolving to deal with the war crimes among them. So and this international military tribunal for the Far East, also known as the Tokyo trial or Tokyo tribunal, it was a military trial. It was convened on April 29, 1946 to try the leaders of the Empire of Japan for joint conspiracy to start and wage war. Okay, because there was there was a joint conspiracy to start and wage war and categorized as class A crimes, conventional war crimes and crime against humanities. So, to deal with these issues, the Allies, set up the Nuremberg and the Tokyo tribunals. Among other principles, these trials also confirmed that individuals could be held criminally responsible for the international crimes, regardless of any official position, and that superior orders were not a full defense to criminal behavior. So you say that like this very one of the features, most important features of the international criminal law, that it entails individual responsibility. It could be traced back to this Nuremberg and Tokyo tribunals, where the trials confirm that individuals also could be held criminally responsible for the international crimes. In the 1940s also, we can talk about the 1948, when the UN General Assembly, because United Nations, the UN was organized, and the UN General Assembly, it adopted the Convention on the Prevention and the Punishment of the Crime of Genocide. Okay, so it adopted this very convention on the prevention and punishment of the crime of genocide, which called for perpetrators of genocide to be tried before international penal tribunals. Okay, this convention it called for perpetrators of genocide to be tried by the international penal tribunals. And following this adoption of the convention, the General Assembly invited the International Law Commission to explore the possibility of establishing an international judicial organ to try those charged with genocide. So, this convention played a very important role, because this convention, it tried that there should be, and also, like soon after this, following the adoption of this convention, the General Assembly, which invited the Law Commission, it also, tried to establish an international judicial organ to try those charged with genocide. And the International Law Commission, it concluded that such a judicial organ was both possible and it was also desirable. And a subsequent committee, it drafted the statutes in 1951 and 1954. And despite these early efforts, the General Assembly postponed the considering the question, and the Cold War prevented the further development of international criminal law for several decades. So you see that like the committee, tried to draft the statutes in 1951 and 1954, but because of the Cold War, it prevented further developments of the international criminal law for several decades. Then in the year 1949, what happened? Like August, you can, the most important date, like August 12, 1949, which led by there were very international events which, which you can see how the international criminal law was evolving. And, led by the International Committee of the Red Cross, a diplomatic conference in Geneva, Switzerland, it adopted the Geneva Convention of 1949. Okay, so there was a Geneva Convention of 1949, and the original four conventions were followed by the additional protocols 1 and 2 on June 8, 1977. And these conventions, these Geneva Conventions and the additional protocols, it form the backbone of international humanitarian law, and they are the binding customary international law on all states and other actors in armed conflict. And each convention, it provides special protection to a group of designated persons, including the civilians, the aid workers, the wounded, and others no longer taking part in active hostilities. So, this convention played a very pivotal role in the, international humanitarian law, and they are the binding customary international law on all the states. The fourth Geneva Convention, it specially outlines the protection which is owed to the civilians in armed conflict. Additionally, the grave breaches regime they created, like the willful killing, torture, or inhuman treatment causing great suffering or serious injury to body or health, unlawful deportation or transfer of protected persons, hostage taking, extensive destruction of property, etc. It informed the later codification of war crimes in the Rome Statute. So you say this convention, the Geneva Convention and the additional protocol, it is a very important convention which helped in evolving the international criminal law. It deals with lot of crimes like willful killing, torture, inhuman treatment, great suffering, serious injury, war crimes, everything. Next, you see what in the year 1960s, like you can relate to May 11, 1960 to May 31st, 1962. So after Israeli secret police arrested Adolf Eichmann, he is prosecuted and convicted in Israeli courts for the ruthless extermination of millions of Jews during World War II. So it marks the first conviction for genocide and a seminal moment in the use of universal jurisdiction by a national jurisdiction for international atrocity crimes. So you can see that this is the first, conviction of for the genocide. Okay, and that is of Adolf Eichmann for the genocide and for the atrocity crimes. So this is how the international criminal law were also like evolving. So Adolf Eichmann was prosecuted and also convicted for the ruthless extermination of the millions of Jews during World War like II, and he was one of the major organizers of the Holocaust, the final solution to the Jewish question in Nazi terminology. So his criminal penalty was that, and he was that penalty was given to him, and so you can say that this marks the first conviction for the genocide. Then in the year 1970s, in the June 8, 1977, they led by the International Committee of the Red Cross, a diplomatic conference in Geneva, Switzerland. It adopted Additional Protocol 1 and 2 to the Geneva Conventions of 1949. And Protocol 1, so you see that there was two additional protocols to the Geneva Conventions, and Protocol 1 provided additional requirements during international armed conflicts, involvement of at least two countries, therefore limiting the way wars can be fought. And Protocol 2, it provided additional requirements and protection that apply during non-international armed conflicts or civil wars. The before Protocol 2, the only restriction applicable to internal conflict were in common article. So, three of the four Geneva Conventions, which required parties to, at a minimum, it protect persons from violence of life and person, humiliating and degrading treatment, and required parties to provide the judicial guarantees, among other measures. So, you see, during the period of 1970s, this Protocol 1 and 2, it provides for lot of crimes, okay, and it gives protection also to the persons from violence to life and persons humiliating and degrading treatment, and required the parties to provide judicial guarantees among other measures. So you see that soon starting even from the pre-Nuremberg tribunals, soon from the 1870s, you can see till 1970s there have been an evolution of the international criminal law, and is still evolving. You will see a different instances or events being taken place, and you can relate to how this criminal law, international criminal law, was evolving with time. Like there were a lot of instances relating to the genocide, crime against humanity, war crimes, and how the situation has led compelled to solve the issue uh, by throughout various conventions, by various additional protocols, various organizations, and various tribunals, and in this manner the international criminal law was evolving to the was evolving with time. So from 1870s to 1970s, you can see there has been a evolution of the international criminal law as a whole. In the next, I'll be discussing the rest of the how instances, how it has been evolving in uh, the next video lecture. I'll be discussing with you the various other instances, like how this process was being evolving with time.